Seafood Sdn Bhd is a company that mainly known to export shrimp and prawn. The case started when the whole country is facing a lockdown due to COVID-19. Due to the MCO, Sunlight Seafood Sdn Bhd see the decrease in the company profit. Then, the company give two options for its employee, which is one, to accept wage cut, or two, take no pay leave until further notice. The situation gets worse when the payment for allowance is delayed and they receive 20% reduction in their last salary payment. Hence, the employee decide to take the 6-month no pay leave. The case escalated when after 6 months, the company failed to recall back its employee. Hence, the employee made two written inquiries about their employment status, but the concern is dismissed lightly by the company. With that, the employee filed claim in Labour Court for benefit and allowance. Labour Court ruled in favour of the employee. However, the employee appealed to High Court for 3 claims, which are food allowance, maternity allowance and termination benefits.
There are 3 critical aspects on this case. First, the law of wages, including food allowances. Second, the law of maternity leave. And third, law of termination benefit. First, law of wages. Wages are defined under Section 2 of the Employment Act 1955 and Sabah Labour Ordinance as basic wages and all other payments in cash payable to an employee for work done in respect of his contract of service. However, this definition excludes certain benefits. A key issue in this case was whether food allowances qualify as wages. Under Section 2 Clause A of both the Employment Act and the Sabah Labour Ordinance, the value of food provided directly by the employer is excluded. However, when food allowances is paid as cash regularly under the employment contract, it is treated as part of wages. In Section 13A subsection 1 of the Sabah Labour Ordinance, employer must pay wages on time and failing to do so is considered a breach of contract. In Section 113 subsection 1 of the Sabah Labour Ordinance, employers cannot deduct from wages unless it is legally authorized. Section 24 of the Employment Act 1955, this section outlines conditions for lawful deduction. Second, law of maternity leave. Maternity leave is protected under Section 37 subsection 1 of the Employment Act 1955, which grant at least 98 consecutive days of leave for female employees. In Sabah, Section 83 subsection 1 of the Sabah Labour Ordinance provided 60 consecutive days of leave. This Section 41A of the Employment Act 1955 protects pregnant employees from being dismissed.
In the Employment Act 1955 show that employers who do not pay workers' wages on time breach the service contract, which is included in Section 15 subsection 1 and Section 19. This breach allows the employee to terminate the contract without notice as per Section 13 subsection 2 for the Sabah Labour Ordinance. We can conclude that Rule 6 Subsection 1 provide detailed guidance on calculating termination benefits, stipulating that employees are entitled to a minimum severance pay of 10, 15 or 20 days salaries for each year of service, depend on their lack of employment with the employer.
This case is an example about employee rights during unpredictable events, specifically during COVID-19 pandemic. Through this case, it clearly shows the Labour Court decision and rationale according to Sabah Labour Ordinance and Employment Act 1955 about employee rights. However, the appellant was dissatisfied with the amount of allowances and benefits calculated by Labour Court. Hence, they appealed the case to the High Court. In this issue, we can see that the Labour Court may apply the definition of wages in the Section 2 of Sabah Labour Ordinance and Employment Act 1955, which is basic wages and all other payment in cash payable to an employee for work done in respect for his contract of service. This clearly shows that food allowance falls under definition of wages. Other than that, the Labour Court also looked into definition of contract of service in Section 2 of Employment Act 1955, which mean any agreement whether oral or in writing and whether express or implied, whereby one person agrees to employ another as an employee and that other agrees to serve his employer as an employee and include an apprenticeship contract. Even though there is no stated food allowance in the employment contract of the respondent was still given the food allowance as evident in their pay slips from the employer. It definitely implies in the contract of service as they were entitled to food allowance as part of the wages. Furthermore, the Labour Code may apply Section 113, Subsection 1 of Sabah Labour Ordinance and Section 24, Subsection 1 of Employment Act 1955 that no deduction shall be made by an employer from the wages of an employee otherwise that in accordance with this ordinance or act. The reference was made when the appellant gave the reason to cut food allowances due to heavy losses during lockdown, and the action is not obligated with the act. After going through this legal provision, the award for food allowance is affirmed by the High Court. Second, for the maternity leave issue, the Labour Court may rely on Section 83, Subsection 1 of the Sabah Labour Ordinance about length of eligible period and entitlement to maternity allowance, that every female employee shall be entitled to maternity leave for a period of not less than 60 consecutive days, also referred to in this chapter as the eligible period. In the respect of each confinement, apart from this, the Labour Court also can apply Section 37, Subsection 1 of Employment Act 1955 regarding this case, but it is different in terms of eligible period. Then, in this case, the respondent is entitled to maternity allowance for 3 months, but the appellant was about to reduce the 3-month allowance by 20% due to the crucial financial status caused by pandemic. However, the Labour Court can again rely on Section 113, Subsection 1 of the Sabah Ordinance and also Section 24, Subsection 1 of Employment Act 1955 that no deduction shall be made by an employer from the wages of an employee otherwise than in accordance with this ordinance or act. Then, the award for maternity allowance is affirmed by the High Court.
For this issue, the Labour Court may apply Section 19 of Employment Act 1955 about time of payment in which the employer must make payment of wages not later than 7 days after the end of the wage period. This reference was made when the appellant failed to pay wages of the respondents after no pay leave for 6 months ended. Moreover, the Labour Court also looked into Section 13A, Subsection 1 of Sabah Labour Ordinance and Section 15, Subsection 1 of Employment Act 1955, which mean an employer shall be deemed to be broken his contract of service with the employee if he fails to pay wages in accordance with Part 3, Payment of Wages. Even though the appellant never had intention to terminate the employment contract of the respondents, it also clears in evidence that the respondent does not agree to extension of no pay leave by the appellant after September 2020.
By that, the appellant had terminated the employment contract of respondent cause of not pay for wages of the respondent after 6 months of no pay leave and not acted bona fide by leaving the respondent in uncertainty about their employment status. From that, the respondent definitely had the right to terminate the contract of service without notice pursuant to Section 13, Subsection 2 of Employment Act 1955, then entitled of termination benefits payment. Furthermore, the reasons given by the appellant for reduction of termination benefits payment cannot be entertained as the Labour Court highly referred to Rule 6, Subsection 1 of Labour Rules 2008 about benefits calculation. Then, the awards for termination benefits is affirmed by the High Court. The Sunlight Ino Seafood case highlights the importance of ethical and legal HR practices. The company lacks of communication and compliance with labour law that led to unnecessary conflict and legal battles. This case set a crucial precedent for businesses to prioritize employee well-being and adhere to labour regulations, especially in times of crisis. There are some case key we would recommend to improve HR practices at Sunlight Ino Seafood Senjam Berhad, particularly focusing on enhancing communication, labour law compliance, and employee support during conflicts. Sunlight Ino Seafood Senjam Berhad can foster a healthier, more positive work environment that will not only improve relationship between employees and the employers but also contribute to the overall success and stability of the company.
To conclude, the case highlights the importance of employers to meet their legal obligation, especially under Section 19 of the Employment Act 1955, which says wages must be paid on time. If wages are paid late, it can lead to legal consequences, employee dissatisfaction, and claims for termination benefits. The court decision underscored that employers must uphold labor rights, including timely payments and fair termination process. Adhering to these obligations ensures employees are treated fairly and respectfully as protected by labor laws at various levels.